We began this process, as mentioned, about a year ago, and basically what we're doing is we're trying to live up to the Supreme Court rulings in the two cases called Sturgeon, in which statehood lands and submerged waters were affirmed. So as we know, the state of Alaska owns our submerged lands, even those located within federal jurisdictions, such as parks, preserves, refuges, monuments. We own the waters, the submerged lands under the waters. This amounts to more than 800,000 miles of navigable waters and 30 million acres of navigable lakes. The problem is, to date, the federal government has acknowledged only 9% of the rivers and 16% of the lakes are in the possession of the state. The federal government has not worked well with us in this area. So today we've got Commissioner Feige, Jim Walker from DNR, Deputy AG Corey Mills, and John Sturgeon to update Alaska on how we are resetting the table with the federal government. So we're going to put the federal government on notice again. The Supreme Court has spoken and the status quo of the past 63 years is over, and we're going to take several actions starting today. The first action we have is we're going to file Quiet Title Act litigation against the Interior Department for 4 submerged land claims in the Lake Clark National Park and Preserve, the Mulchatna River and the Chillicothe River, Twin Lakes, and Turquoise Lakes. And the reason for the litigation, BLM has wrongly declared that these waters are non-navigable in order to defeat the state's interest in claiming sovereignty over these lands and waters. Second, this morning we have sent a cease and desist notice of trespass letters to the Interior Department and USDA regarding federal infrastructure on state-owned submerged lands that lack proper permits. And I'll be personally sending a letter to Interior Secretary Holland and USDA Secretary Vilsack informing them of these actions. Notice of trespass letters apply to existing infrastructure we have determined require state permits. Cease and desist letters apply to infrastructure still in the planning stages and to federal actions such as attempts to close Mendenhall Lake to motorized craft. Mendenhall Lake is a water that belongs to the state of Alaska, and motorized craft are permitted on that lake. I repeat, motorized craft are permitted on that lake. Permitted activities are solely the purview of the state, as the Supreme Court has ruled twice. We are making it clear that the federal government needs our permission. We don't need their permission to be on our lakes. They need our permission to be on our lakes, to build or operate infrastructure on state lands. We are sending these letters because the federal government has yet to provide the state with an inventory of all the infrastructure that is on our lands, despite a request for this list more than a year ago. Thirdly, we have completed our assessment of navigable waters, owned and managed by the state within the National Park Service units and the Tongass National Forest. The work is currently progressing on the Chugach National Forest and U.S. Fish and Wildlife Service units. The map of these assessed waters is now available on the DNR website, and we have legislation introduced in both the House and the Senate that will codify these bodies of water as state-owned. We continue to pursue what we call the restitution project as we identify submerged lands that were wrongfully charged against our statehood entitlement. Under the statehood compact, these submerged lands always belong to us. I repeat, these submerged lands under the statehood compact always belong to us, the state of Alaska. Yet in some cases, we've been overcharged by the federal government. To date, we've identified about 100,000 acres that were wrongly counted against our statehood selection. So in other words, before the lands were even selected, before the state lands were selected under the statehood compact, the understanding would be that the submerged lands and waters would be given to the state of Alaska, then the selections would take place on top of that. That may not sound like a lot, but we expect the number to get much larger. As a matter of principle, we will not concede 1 inch to the federal government that belongs to the state of Alaska. We will not allow the federal government to continue slow-boating its compliance with 2 unanimous Supreme Court rulings that declared once and for all that the state of Alaska owns and controls our navigable waters. We're resetting this relationship, and we'll pursue the Unlocking Alaska initiative relentlessly with every available tool for the maximum benefit of all Alaskans. So with that, I'm going to turn this over to Deputy AG Corey Mills, who has additional information about the actions we're announcing today. Corey?
Thank you, Governor. Again, Deputy Attorney General Corey Mills on behalf of Attorney General Taylor. And I'm going to kind of outline what is the legal groundwork here and clear up a few misconceptions that I think often come up in this area. So as a starting point, these lands, these submerged lands over which the water flows, were held in trust by the federal government and were conveyed to the state under the U.S. Constitution, under the U.S. Constitution's equal footing doctrine. This occurred at statehood. On the day we became a state, this happened. That conveyance was then codified. It's been codified in the Submerged Lands Act as well as by Alaska's Statehood Act, as the governor was indicating. So historically, the state, I've heard a lot about, well, don't you just lose a lot of lawsuits? That's not true, for one, but the state has had a lot of success with navigable water litigation. We have won every single case we have brought in this area. And yet, despite the state's success, the federal government continues to refuse to sit down with us across the table and work out these issues, and instead forces us to go to the courtroom. So there's a misconception that these lands were taken away. It's like we're asking the federal government to give us these lands. That's not the case. That is a false statement. Alaska was already given these submerged lands, as I said before, at statehood. The issue is that the federal government is refusing to recognize what is rightfully the state's. To bring this home, as an example, this would be similar to your neighbor asserting that your driveway is actually not yours, that access to get to your house belongs to somebody else. It's the same with our submerged lands. The state owns these submerged lands. It's just that the federal government is failing to recognize that ownership right. So we've brought many of these cases over the decades. In one of our cases, this involved the Mosquito Fork of the 40 Mile. The federal government's unwillingness to work with the state actually resulted in a ruling of bad faith by the Alaska District Court. And that bad faith ruling meant that the state was able to get from the federal government much of the attorney's fees that it spent litigating that case. The ruling of bad faith came because the federal government made the state go through all the steps of litigation, and then on the very eve of trial, they disclaimed their interest that they had asserted they had. And so, like I said, this was a ruling of bad faith, and yet despite this ruling, we're still not getting the federal government to come to the table. Later in the press conference, you will also hear from John Sturgeon, an Alaskan that actually had to fight his way up to the Supreme Court 2 times to get the federal government to recognize those management rights. In that case, the federal government did recognize that the state owned it, but the federal government still said, but we can still manage it despite your ownership. And the U.S. Supreme Court resoundingly said, no, the state owns it, the state manages it. Again, despite these cases, we're trying to work with the federal government. We'd love to sit down and get these recognized in a negotiating table instead of in a courtroom, but that just isn't happening. And that means that we need to continue to assert our rights in every possible manner. So currently, the state is involved in a number of lawsuits, and we're filing another one today. As the governor indicated, this one involves rivers and lakes in the Lake Clark National Park and Preserve. Twin Lakes, Turquoise Lake, Mulchatna River, and Chillicothe. And so that lawsuit will be filed today, and it will be another step towards forcing the federal government, hopefully, to recognize those rights that Alaska already has. Governor?
Yes, I am. Thank you. Thank you, and good afternoon, everyone, and thank you, Governor and DAG Mills. It is a pleasure to be here with you all today to give you an update on the Governor's Unlocking Alaska initiative. The assertion of the state's ownership rights and our management authority may not be flashy material, and yes, it is nuanced, but I cannot overstate how incredibly important this action is to the state of Alaska and to Alaskans. So we get asked very frequently, why all the lawsuits? Why the litigation? Well, you've just heard from DAG Mills that these actions need to be taken simply because our good faith efforts to work with the federal agencies are bearing no fruit. They're ignoring us, they aren't speaking with us, they're not working with us. And so unfortunately, it leaves us with litigation as the final posture. Now, before I go too far, I want to make sure that the public and Alaskans understand when we are talking about state submerged lands, what are we talking about? State submerged lands are those lands that reside below the ordinary high water mark, and they lie under the nearly 800,000 miles of navigable rivers and over 30 million acres of navigable lakes across the state. These lands, as you've already heard, came into state ownership at statehood 63 years ago, but the federal government continues to this day to fail to recognize the state's rights and authorities. So why does this matter to Alaskans, and why should all of you care? It matters because Alaska uses our lakes and rivers very differently than any other Western state, than any other state in the nation. These rivers and lakes are literally the arteries that connect our communities, and they facilitate commerce, and they facilitate commercial activity across the state. And so taking actions like the Unlocking Alaska initiative does make a huge impact. You can see the map here to my right. Prior to 1 year ago, when the governor asserted the state's ownership and management authority, the federal government believed that they owned everything in pink and that the state of Alaska owned everything in blue. We fast forward to today, 1 year after asserting the state's rights and authorities, and this is what Alaska owns and what Alaskans have the right to use without federal interference. Now, as we said, standing here just 1 year ago, the state does recognize that there are docks and other infrastructure that the federal agencies, like the National Park Service or the U.S. Forest Service, have constructed on state submerged lands, especially in federal parks and places like the Tongass National Forest. We said a year ago that we would work with the federal agencies to get these converted to compliant status and placed under state of Alaska permits. It's not in our interest to disrupt the open water season. And over the course of that year, we have asked repeatedly for a list of these constructions. And all we've heard is that the Department of Interior has now formed an internal working group to try to decide how they're going to develop this list of these constructions. And so, given this lack of construction, the lack of cooperation and the continued foot dragging, my office today has issued cease and desist letters for constructions that are pending installation at Mendenhall Lake. The Forest Service would like to construct a dock onto state submerged lands, and they cannot do so without state permits. Further, as the governor mentioned, they would like to say that there will be no motorized watercraft use on Mendenhall Lake. They do not own Mendenhall Lake. Alaskans have the right to use motorized vehicles on Mendenhall Lake. And finally, the state has the authority to monitor and permit any commercial activities on Mendenhall Lake, not the federal government. My office today has also sent a notice of trespass letter for constructions that are already in place on state submerged lands. These would be things like the dock at the Crescent Lake Ranger Station located within Lake Clark National Park and Preserve. Now, these are not steps that the state wants to be taking. We would much rather be working with the federal agencies and our counterparts to help make Alaska whole and have our rights and authorities respected. But that is just not the response that we're getting. And this has been the pattern for many, many years. You might be surprised to know that a significant amount of federal money has been appropriated to the BLM Alaska Region Office specifically for the purposes of clearing title to state submerged lands and making land state conveyances. Roughly $118 million just since fiscal year 18. So we'll have a slide here. I'm going to show you they have only to date recognized 9% of the state's ownership of submerged lands below the 800,000 miles of rivers, and they've only recognized 16% of the submerged lands being in state ownership under the 30 million acres of navigable lakes. And yet, in just the last year, with the governor's leadership on the Unlocking Alaska initiative, the state of Alaska has identified an additional 8,971 miles of rivers within National Park Service areas and the Tongass National Forest. That's an increase of 76% state ownership. And we have recognized another 488,992 acres of submerged lands below lakes in the National Park Service areas and in the Tongass National Forest. That's an increase of 219%. And what have we seen out of the federal government? One recordable disclaimer of interest. And so the state, through our congressional delegation, has requested that the Government Accountability Office undertake an audit of just exactly how the money that Congress has appropriated to BLM Alaska has been spent, because it certainly has not been spent on recognizing and resolving state title issues on submerged lands or conveying lands to the state as Congress intended. And finally, the governor has introduced new state legislation that, if adopted, would codify and establish in state law state submerged lands in National Park Service areas and in the Tongass National Forest. Within those bills, and it's SB 227, and its companion bill on the House side is HB 397. Within that legislation, there are 1,873 very specifically named water bodies and rivers within National Park Service areas and the Tongass National Forest that, once this legislation is passed and those lands are clearly affirmed in state ownership, it will then be up to the federal government to come to the state of Alaska and make the case that a given water body or river is not navigable. No longer will it be the state spending the money to go acquire the data and make the case that something that we already own is ours. We have turned the tables. I cannot express how very important this legislation is to statehood defense. We know that Senate Bill 227 is currently in Senate Resources and is scheduled for a hearing tomorrow, and we are optimistic that that will be passed out of the committee this week and go to the Senate floor. HB 397 on the House side is currently sitting in the House Fisheries Committee, which is a special committee, and its next committee of referral is House Resources. Right now, we are aware that the House Resources Committee schedule is fairly open, and DNR will be pushing for hearings on that bill and advancing this bill to the floor as soon as possible. Alaskans should know that DNR and this administration will continue this work, and we will take even more steps to assert the state's rights as they relate to submerged lands. DNR has put forward a very strong budget and to continue this work, and we have been very pleased to work with the legislature in the discussions in moving our budget forward so that we can continue this very important work on behalf of Alaskans. So now I would like to introduce Mr. Jim Walker, who heads the Public Access Assertion and Defense Team within DNR's Division of Mining, Land, and Water. Jim?
Thank you, Commissioner Feige. As you'll see from the slide, which is being shown now, this depicts all of the component parts of the Unlocking Alaska initiative. Already today, from the governor, from Deputy Attorney General Mills, as well as Commissioner Feige, we have heard about the progress that this initiative has made on the front, on the management of state waters. I would like to address a few of the additional points, a few of these additional component parts of the Unlocking Alaska initiative. And again, to go back to the Mendenhall Lake situation, as you have already heard today, as recently as last month, federal planning authorities have essentially, in defiance of the rulings, in defiance of state ownership of the submerged lands, have very blithely said, we don't care what the ownership of this water body is. We are going to regulate who can use it, under what circumstances they can use it, and we're going to put up whatever infrastructure we want to without the need for state permits. This attitude has to be addressed, and that is one of the main focuses of the Unlocking Alaska initiative. So, for example, one of those component points is we are launching this month state transportation management plans for the state of Alaska, beginning with the 40-mile region and ultimately covering the entire state. We will be deciding what Alaskans can, how they can use the RS-2477s in state navigable waters. Instead of applying and commenting to federal agencies regarding what should be the proper uses, we are going to decide, we Alaskans are going to decide what our property interests can be used for, and we intend to vigorously proceed with these state transportation management plans statewide. We are also working hard, as Governor Dunleavy indicated, on our restitution project. And as you can see on the next slide, which depicts an area that should have been meandered, should have been excluded from the state's charge against its state landhood entitlement, but was not. These are the types of things that we are identifying. Our work is continuing. As Governor Dunleavy indicated, we have identified approximately 100,000 acres of land that were wrongfully, the state was wrongfully overcharged and should still be due and owing against the state landhood entitlement. Our work is continuing, and we expect this number to at least double or triple before we are done. You know, as I indicated, the Unlocking Alaska initiative has many component parts, but the one underlying theme underneath all aspects of this initiative is that the status quo will be no more. The status quo, which has poorly served all Alaskans for the past 63 years, will be no more. Instead of accepting whatever table scraps the federal government chooses to throw our way at its sole discretion, we will take what is rightfully ours and assert sovereign dominion over the same. With that, I would like to return the podium to our governor. Thank you.
Thanks, Jim. And in a second, we're going to have John Sturgeon come up, say a few words. As many of you know, John had to take two cases to the U.S. Supreme Court and won both cases. The only person in U.S. history to do that. And because of that, Alaska, and quite frankly, this country is in better shape with regard to its relationship with the federal government. So what we really have occurring here is a situation where courts have ruled, the Constitution is clear, there's laws in place, but there are agencies and individuals within certain federal agencies that have taken upon themselves to have a totally different view of how Alaska should be treated. And what we're basically saying here today is we're going to hold your feet to the fire. We're going to follow the law. You're going to follow the law. We're going to follow the Constitution. You're going to follow the Constitution. Starting last year, we also said that any of our citizens that were harassed or otherwise bothered on our navigable waters and submerged lands, we wanted to know about those incidents. We will have updates on our website and DNR regarding water such as Mendenhall Lake. Again, it's a state navigable water. You can use motorized traffic boats on that lake, as well as the river. And we're going to continue to press our case. And from this point forward, we are going to assume total sovereignty over our lands and water. And so what we're doing is asking the federal government to recognize what the courts have recognized, what the Constitution recognized, what the Statehood Act has recognized, that there are certain lands and waters within the state of Alaska, the boundaries of the state of Alaska, that belong to the state, always have belonged to the state, and we will be exercising our sovereignty over these lands and waters. If Alaskans are harassed, if Alaskans are bothered, we will intervene on their behalf in an effort to make sure that our people are free to use the state of Alaska's lands and waters. So with that, I want to turn this over to John Sturgeon for a few minutes to just say a few words and remind us of a few things that have occurred over the years here in the state of Alaska. John?
Well, thank you, Governor. Good afternoon, everyone. My story started in September of 2007 while I was moose hunting on a tributary of the Yukon River near Eagle, Alaska, in the Yukon-Charlie National Park Preserve. It's an area that I have hunted for 50 consecutive years. I was operating a small 10-foot hovercraft, and I was approached by two National Park Service employees, enforcement officers, and they informed me that hovercrafts were prohibited on all national park waters. That wasn't intuitive to me. If you were spilling oil or something like that, you'd say, well, that's something that's probably not good, but had no idea that hovercrafts were not allowed. I informed them that I was on a state-owned navigable water. In fact, the Nation River, the river I was on, was actually a test case that was declared navigable by the courts many years before. They acknowledged the state owned it. That wasn't a problem, but they said the uplands were owned by the federal government, so they had authority to do management on that navigable river, and the Yukon, by the way. Unfortunately, I didn't get a citation. That made things a lot easier. That started a 13-year, $1.6 million journey through the federal court system, which, by the way, was paid for by hundreds and hundreds and thousands of Alaskans over a period of 13 years. My case, between 2019, was one of 8,000 cases submitted to the Supreme Court. The Supreme Court only took 41 cases. That works out to about 0.5% of the cases they actually took. And it resulted in 2 unanimous Supreme Court decisions. In fact, the Washington Post did a story on my cases, and they said they could not find another civil case that had 2 unanimous opinions since the United States started. So that's quite a feather. What did these 2 unanimous Supreme Court decisions say? Let me read you some, what I think are the more important quotes from the decisions. And I'm reading these verbatim. And the rivers function as roads of Alaska to an extent unknown anyplace else in the country. Over 3/4 of Alaska's 300 communities live in regions unconnected to the state's road system. Residents of these areas include many of Alaska's poor citizens who rely on rivers for necessities like food and water. That's a quote from Justice Elaine Kagan. It also said, all navigable waters in Alaska we managed by the state of Alaska, not the federal government. The Supreme Court also said, all inholdings, especially navigable waters and submerged lands, are exempt from federal management. If they want to manage them, ANILCA says they have to buy them. It also said, since state, native, and private inholdings are not part of the park, therefore the regulations do not apply. These inholdings should be treated the same as they would prior to ANILCA, and that's a quote. The courts also made some very broad statements on ANILCA, saying it was a grand compromise. A lot of people forget about that, establishing our parks and preserves and refuges. It had 2 stated goals. This is a quote from the Supreme Court. First, to provide sufficient protection for the national interest in the scenic, natural, cultural, and environmental values on the public lands in Alaska. And the second, which some people forget about sometimes, and second, to provide adequate opportunity for the satisfaction of the economic and social needs of the state of Alaska and its people. That is a quote. It also said many times during the two Supreme Court decisions that Alaska was different. Alaska was different by law. ANILCA made Alaska different, and it should be treated differently. Our parks, preserves, and refuges are not to be treated like Yellowstone or Yosemite or the other parks down south or the wildlife refuges. Alaska had many, many special provisions to help in that second part I read for the satisfaction of the economic and social needs of Alaskan people. And finally, I'd like to include my most favorite quote from the Supreme Court, and this is an exact quote from Justice Elaine Kagan. It says, "That means sturgeon can rev up his hovercraft in search of moose." Justice Elaine Kagan. That's my favorite, and I've been telling my wife ever since that the Supreme Court ordered me to go moose hunting. It hasn't worked, but I'm hoping this year it's going to work. You would think that with two unanimous Supreme Court decisions would get the federal agency's attention. So what has happened the past 3 years since my unanimous Supreme Court decision in regards to the feds passing title of navigable waters to the state? Unfortunately, absolutely nothing. Not one navigable water has been transferred to the state of Alaska since 2019, my 2019 U.S. Supreme Court decision. Since statehood, only 9% of navigable waters in Alaska have been transferred from federal ownership to the state. That's 63 years. At that rate, it will take 600 years to get title. All the other states have gotten their titles of navigable waters many, many years ago. I'm from the state of Minnesota, and it was done 100 years ago. It would appear that the federal agencies are thumbing their nose not only at the state of Alaska, but the U.S. Supreme Court. Why would Alaskans prefer state management over navigable waters over federal management? For one thing, the federal government manages for maximum biodiversity. The state manages for maximum sustained yield. That means the state has a lot more tools in its toolbox to do things like for predator control, for hatcheries, for fish enhancement projects. The state is much more flexible in doing those things. So if you're a commercial fisherman or a subsistence fisherman, it makes a big difference who manages the lands. There are a few reasons why all Alaskans should support me in the fight for access. Some 80% of Alaska towns and villages do not have road access. The mighty rivers as the Yukon, Kuskokwim, Stikine, Susitna, to name a few, are Alaska's superhighways since the first indigenous people arrived in Alaska. To many, these waterways are just as important as they were 1,000 years ago. There are highways in Alaska. And finally, one of the things that makes America truly great is we believe that when our government is wrong, a private citizen can actually make a challenge, which I did. That is unfortunately not an option in a lot of governments across in this world. I've told you about my 13-year, $1.6 million, 2 trips to the U.S. Supreme Court. It was a victory not so much for me, but for hundreds and thousands of little guys like me that know it is possible to take on and win against the most powerful government on earth. So you can imagine my frustration and disappointment 3 years ago when my unanimous Supreme Court decision from the federal government has done nothing to complete and has completely ignored that decision. They have not approved one navigable water. Alaska received ownership of navigable waters the day we became a state. That the feds don't acknowledge that should be upsetting to Alaskans, every American, regardless of their political affiliation. And I'd like to thank, along with lots of other Alaskans, especially the sportsmen, fishermen, thank Governor Dunleavy and his staff what they have done to try to take control of our navigable waters, our submerged lands, and our RS-2477s. Thank you very much, Governor Dunleavy, and all your staff. Thank you.
Thanks, John. You know, you should have never had to go through that. In a way, we're glad you did for the state of Alaska and for this country, but nonetheless, going forward, we're going to make sure that the future John Sturgeons don't do this by themselves, but they have the state with them. At this point, we'd like to open this up for questions. So, Patty?
We have 8 reporters online. Some of them have questions. And Anthony Moore with KSRM, do you have a question?
had last year. You said that Corey Feige was going to send letters to the Interior Secretary to cease management and oversight of such lands, but isn't under ANCSA the Interior Secretary given that management oversight? Thanks.
Corey.
Yeah, Corey Mills again, Deputy Attorney General. No, ANCSA does not give any sort of management authority to the federal government over these state-owned navigable waters that were owned at statehood.
Okay. Up next is Peter Siegel, Juneau Empire. Do you have a question?
Yes, Governor, I'd like to ask about the timing of this. Why weren't these suits filed earlier in your administration? Thank you.
So we've been looking at, again, we started last year, and prior to that announcement last year, we had spent some time on examining court cases, examining our navigable waters, our submerged lands, where they were, cataloging them, looking at what was done over the years. And so certainly we started well before last year on this endeavor. This is just a continuation, and we will continue to do it, but this has been a couple years in the making, Peter.
Okay, Sean McGuire with KTUU. Are you on the line? Do you have a question?
I do, thank you. Governor, you were saying you want citizens to tell us if they've been bothered, and you said if Alaskans are harassed, we will intervene on their behalf. You talked as well about motorized transport on Mendenhall Lake. Does it mean if Alaskans break the quote-unquote rules as they stand now, and say the Forest Service finds someone, that the state will step in and pay the bill? Are you encouraging, again, quote-unquote, breaking the rules?
No, well, Sean, first of all, it's the agencies that are breaking the rules. As was mentioned in the press conference, the Supreme Court has ruled. We have statehood, the Statehood Act has embedded in it agreements and understandings with regard to submerged lands and waters. So if anyone is breaking the rules, it's agencies and agency personnel. What we're telling the state of Alaska is you don't have to live in fear of the federal government flying in on your camp if you're on a state navigable water submerged land or being harassed by federal agents. That's what we're telling Alaskans, and that's quite frankly the way it should be. We shouldn't be bothered in utilizing our state rivers and our state lakes and state submerged lands. And so I'm not encouraging anyone to break the rules. I'm actually trying to discourage the federal agencies from continuing to pretend or act as if they have jurisdictions over our submerged lands and waters, when in fact they don't. And so this is really a statement about not living in fear of your federal government agencies or agents. It's basically telling everybody what is legal, what is constitutional, and informing Alaskans that if they are bothered by agencies or agents of those agencies, that they need to let the state of Alaska know so we can help out.
Okay, Jeff Landfield with Alaska Landmine. What's your question?
Hi, I just had a question, something related. About 2 years ago, the state and the city acknowledged that the waters of Campbell Lake were navigable and had public access. And residents continue to be harassed by some people on the lake. Why hasn't the state done anything to provide access to the largest lake in the largest city in Alaska?
What was the last part of the question?
Why isn't there anything to protect the largest city?
We've acknowledged access, correct?
Yes, Jim can speak to.
Jim, you want to talk?
Yeah.
With regards to Campbell Lake, the state, along with the municipality, has issued a statement indicating that the waters of Campbell Lake are subject to the public trust doctrine. The waters belong to the people, and the people can use those waters. With regards to the section line easements that provide access to Campbell Lake, the statement that was jointly issued with the municipality of Anchorage also provides the public access points on both the north and south side to Campbell Lake. With regards to the Unlocking Alaska initiative, this is concerned with federal areas statewide. Federal areas such as National Park Service units, with regards to U.S. Fish and Wildlife Service refuges, BLM lands, U.S. Forest Service areas. Campbell Lake does not fall within the purview of this federal initiative.
Up next is Alex DeMarvin with ADN. Your question?
Yeah, thanks. Just wondering if there are concerns whether the acknowledgement of more navigable waterways could give the Corps more permitting authority over those waterways the state may not one day appreciate.
Well, the hope is, we hope not, but Cord, do you want to address that?
And Corey Mills. So navigable waterways, there's terminology in the Clean Water Act referring to navigability that is a different navigability than, under the Submerged Lands Act. So there's no relation to the two. It doesn't change any sort of status under those laws. As you may know, we've also, on the Clean Water Act front, filed an amicus brief on the recent Sackett case to try and get the U.S. Supreme Court to better define waters of the United States, to more narrow that as well. But these are two completely different laws. You have to look at two different sets of case law in order to define what navigability is under both of those.
Okay, thanks.
Okay, Liz Ruskin with Alaska Public Media. Are you on the line? Okay. Governor, do you want another round of questions, or that was our last question?
Sure.
Okay. Let's see. Anthony Moore, do you have another question? Question number 2.
I do not, thank you.
Okay, thank you. And Peter Segal?
Yes, Governor, how did the state come to the determination that motorized vehicles could be used on Mendenhall Lake? Thank you.
Because it's a state water, and we are able to use motorized vehicles on our state waters.
Jeff Landfield, do you have another question?
Oh, I don't, thank you.
Okay. How about Sean McGuire, KTUU?
Sorry, just following up on, again, what Peter asked about the motorized transport. If you were to get fined on Mendenhall Lake for using motorized transport, what should Alaskan residents do?
They should go to our DNR website. We're going to have a phone number there. They should call in the incident. We'll determine to what degree, what steps should be taken to assist our citizens using our own waters. We're hoping it doesn't happen, but we're prepared to intervene when our Alaskan citizens are wronged by certain federal agencies or agents. Patty?
Thank you. I just noticed that Olivia Eberts, are you on the line? Okay. And let's see. Last question then would be Alex DeMarvin with ADN.
I think I'm good for now. Thanks.
Okay. Well, thanks, folks, for being online, and thanks for the questions. What we really want to tell Alaskans is this has been since statehood, since we became a state, 59. This has been an ongoing issue with the federal government. We have agreements. We have Supreme Court rulings. We have law behind us. For reasons we really don't know, we can't answer, there are certain federal agencies and certain federal agents that insist that they're going to ignore some of these laws and some of the court actions. We're not going to ignore them. We're going to vigorously implement our sovereignty over our lands and our waters. We'd like to work with the federal government, but we're not going to be subservient to the federal government on our lands and waters. They are our lands and waters. To my knowledge, no other state has to go through this. This is almost a weekly, monthly basis with the federal government. The fact of the matter is we are a state, we're the 49th state, within a federal system. Agreements have been made. Agreements need to be implemented. What we're doing is pressing our case. It's a legal case, and we'll continue to do so. We simply want our lands and our waters. We're going to use our lands and our waters. If the federal government has structures on our lands and waters, or they're planning on putting structures on our lands and waters, they need to have a discussion with us first, and that's what this is about. And so Alaskans, go to the website, the NR website, look at the maps. You'll see what waters, submerged lands and navigable lakes and waters are sovereign to the state of Alaska. You can use those waters, despite what some may say that are part of federal agencies. If you have a question, you just get a hold of our Department of Natural Resources. We'll get you the answer. And it's our hope that this issue is going to be settled quickly. If not, we're prepared to litigate it. But in the end, this is an issue of sovereignty within the framework of our federalist system. So with that, I want to thank you for your time, and we look forward to going boating this summer on our waters. Thank you.
Thank you.